My name's Darren Senga, head of VLF's Dallas office. I'm joined today by Jeff Sines from VLF San Antonio office. Welcome to another installment of Vethin Law Firm's video educational series. Jeff, today we're going to talk a little bit about rescission, or the concept of the contract that never existed. So Jeff, can you tell the folks a little bit about what a rescission actually is?
Absolutely. Rescission is an equitable remedy. It's a judicial decree that the court's essentially putting the parties back in the position that they were in had they not even entered the contract. So it's like a cancellation of the contract, but it's really putting the parties as if they never began negotiations and no transaction happened at all.
Hence the topic, the contract that never existed. In broad terms, it's fair to say, I think, that Texas courts generally disfavor rescission, but we've identified, I think, two areas in which they're the most common, and they're related concepts. One is at common law, judge-created law, under the concept of fraud, and the other is for a violation of the Texas Deceptive Trade Practices Act. Now, Jeff, of course, the Deceptive Trade Practices Act, or the DTPA, doesn't always apply, right?
No, the DTPA does not always apply, and we do have on our website blogs that go more in detail about this topic, but generally it's when there's a consumer transaction.
Or sometimes small business.
That's right, and there's always the common thread of whether the defendant or whether the seller typically acted in bad faith in getting to the sale.
So that bad faith element is one of the key things you need to think about if you're looking for rescission. And the other is the issue that actually binds together those concepts we were talking about, the DTPA issue and the fraud issue. It's the warranty issue. So from a practical perspective, think about bad faith and think about warranties, and specifically implied warranties.
That's right.
What are the implied warranties we typically see?
The implied warranties that we typically see are first the implied warranty of merchantability, and what that essentially is it's warranting that it's promising that the good that you're selling is it's fit for its ordinary purpose. It does what the consumer would expect to do.
So in a legal sense, sometimes you see that written as it meets the description of the goods as understood in the trade. Effectively, that just means the words that describe it are what they say they are.
That's right. And then the second implied warranty is the implied warranty for fitness for a particular purpose. And that typically comes when the seller makes some representations of expertise, or when the buyer comes for a specific purpose. He's looking to see if there's specific application of that good, and the seller warrants that it will work for that purpose.
I get it. Let's try to break that down into a concrete example. Perhaps something as simple as a computer. Mm-hmm. If I walk into a store and a computer is advertised, today in 2019, a computer is advertised as being new and state-of-the-art, does that trigger any of those warranties?
Well, new and state-of-the-art, that typically triggers the implied warranty of merchantability.
Meaning that in this instance that it would need to have a reasonably up-to-date processor, presumably an operating system, that kind of a thing.
That's right.
And then let's talk about the other warranty, the implied warranty of fitness for a particular purpose. How might that apply in our computer example?
So let's say that the buyer comes in asking, will this computer work for Mario or for the latest game that's coming out? And the seller warrants that it will work for this purpose. Then right there, the implied warranty of fitness for a particular purpose was invoked.
Exactly. So once you've got a violation of one of these warranties, that's not necessarily itself enough for rescission. The evidence would have to show that the seller, in making those implied warranties, at the time of making those implied warranties, was acting effectively in bad faith. That is, that they didn't intend for the goods provided to actually meet either one of those warranties. There's kind of a knowledge requirement there, what we call scienter. There's a requirement that it not simply be badly done, but that it never intended to have been done properly in the first place. Slight distinction, it's an important one.